Every day there are a ton of legal sounding phrases spouted on social media, a lot of which are complete and utter nonsense. So in this video I'm going to go through some legal myths and let you know whether or not there is any truth behind them. Let's get into the video. Surprisingly, this one is false. Now, whilst many of us would not like someone we do not know taking our photograph without our permission, there is no law preventing someone from taking a photograph of you in a public place. Now, unless the image taken of you could be deemed as indecent, you cannot force a photographer to stop or indeed delete a photograph of you after they have taken it. Now, there are some exceptions to this, such as laws preventing photographs being taken in a specific place, but these are usually in relation to terrorism offences. And indeed, if you are being harassed by someone taking a photograph, then that in itself could constitute a criminal offence. But in general, it is not illegal for someone to take your photograph in a public place without your permission. This one is also false. The term pressing charges is not a term used in England and Wales. If you are the victim of a crime, then you must report the matter to the police via a statement or a video recorded interview, and then the police will gather evidence and refer it to the Crown Prosecution Service, and it is them alone who decide whether or not to bring a charge against the perpetrator. And whilst a victim of crime refusing to give a statement to the police would likely hinder an investigation and a prosecution, a victim cannot demand that a charge is brought against the perpetrator. Now, one of the things a victim can do, however, is to sue the individual in civil court, and this is for matters such as being assaulted or suffering trespass to your land, but this is completely separate to any criminal proceedings. The decision on whether to charge is for the Crown Prosecution Service alone and not the victim. Now, this one is partly true. So you may have seen one of these signs which threatens to prosecute people for trespassing on private land. Now, the previous position before June 2022 was that trespassing was not actually a criminal offence in of itself. It was treated as a civil wrong or a tort and was not a matter for the police. Now, this changed in June of 2022 when a criminal offence of trespass was created, where someone is trespassing on your land who refuses to leave and is causing or is likely to cause significant damage to the land. Now, this is under Section 60C of the Criminal Justice and Public Order Act 1994, which was amended by a new act that came into force in 2022, which was the Police Criminal Sentencing and Courts Act. However, as we've already learned, a private individual cannot or does not have the power to charge someone with a crime. Only the Crown Prosecution Service can do that. So whilst technically trespassers can be prosecuted for a criminal offence of trespass, the owner of the land has no power to prosecute that individual. So this one is also partly true, depending on the type of the offence, which affects whether or not you are entitled to a trial by a jury. If the offence is what's known as an indictable only offence, and this is serious offences such as murder, rape or robbery, then you can only be tried by a jury. If the offence is what's known as an either way offence, this is things like theft or assault occasioning actual bodily harm, then you can choose whether or not you wish to be tried by a jury or have your case heard in the magistrate's court. But if the offence is known as a summary only offence, and this is things like battery or most motoring offences, then you have no right to be tried by a jury. So out of the three types of offences, on two of the types, the most serious, you do have a right to have a trial by a jury. But if the offence is summary only, you do not have that right. This one is 100% false. Judges do not use gavels in England and Wales. Now, despite this, you will see in a ton of legal publications, including those put out by the government, of gavels or judges using gavels. But these are used in America by American judges and are not and have never been used by judges in England and Wales. So there you have it. Most of these turn out to either be false or only partly true. Now, if you do have any other legal myths that you want answered, please do drop a comment below, and what I'll do is I'll collate these and then do another video. If you did enjoy this video, then please do consider giving it a like, and if you'd like to see more from me, then please do subscribe to my channel. Thanks for watching, take care.